Good morning. We are on the record. This is the digital video deposition of Irina Cole testifying in the matter of Lyle Weisman versus County of Los Angeles et al.
Sean McMillan, appearing for plaintiff Lyle Weisman.
I'll be Berkowitz on behalf of the defendants.
And the witness may now be sworn in.
All right, would you raise your right hand for me, please? You do solemnly swear that the testimony you're about to give in the cause now pending shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
You may proceed.
Okay, can you please state and spell your full name?
Irina Lanice Cole, A-R-E-N-A, Lanice, L-A-N-E-I-C-E, Cole, C-O-L-E.
You're currently employed by the County of Los Angeles?
I am.
And how long have you been employed by the County of Los Angeles?
Just shy of 24 years.
So about 1990 is when you started?
Correct.
What position do you currently hold with the County of Los Angeles?
Supervising children's social worker.
We call that an SCSW, right?
That's correct.
How long have you been an SCSW?
I want to say about 17 years.
What position did you hold before you were an SCSW?
Children's social worker, 3.
How long were you a CSW 3?
I want to say a little more than 6 years, perhaps.
As a SCSW of the last 17 years, what region have you been posted in?
The same region. I've only worked in the one region.
And that is what?
San Fernando Valley, Chatsworth office. We were previously Panorama City in North Hollywood.
Okay. As an SCSW, part of your job duties include supervising CSWs, right?
CSWs, yes.
Mm-hmm. How many did you supervise in 2009?
It varied, I want to say 6 to 7.
How many do you supervise today?
Presently 5.
And in the late 2011, early 2012 time period, how many did you supervise?
6.
Was one of those people Carla Hosch?
That's correct.
As her supervisor, what were your, just describe for me generally what your duties entailed.
I'm responsible for overseeing, primarily reviewing court reports, consulting whenever needed, assisting with crisis intervention, being on hand to consult with primarily.
Okay. You don't yourself, at least back at that point in time, 2011, 2012, you didn't yourself conduct investigations, right?
No.
No, I'm not right?
No, I did not. Yes, you're correct.
Okay. You didn't go out in the field and interview witnesses?
No.
And I'm also correct that you did not regularly double check the work of your social workers who did actually go out in the field and interview witnesses.
I'm not quite sure what you mean by double check,
Okay.
because my workers are, I trust their level of professionalism, but yes, it is my job to consult with them, particularly as it pertains to information that they gather.
Okay, and what do you mean by consult with these workers that you trust?
On a daily basis, I talk with my staff with regard to the cases that are assigned to them.
In your 24 years with the agency, have you ever heard of a social worker being disciplined for making false statements in a court report?
I know that it exists. I don't know. I have not had any firsthand dealings with that.
Have you ever, my question though was a little different than that. My question was, in your 24 years with the agency, have you ever heard of any social worker being disciplined for making untrue statements in a court report?
I have not heard, but I know that's a possibility.
When you are consulting with these subordinates that you trust, what do you do, if anything, to cross-check their work?
Well, primarily when I am reading their documentation, there's a certain information that I look for typically, and it typically starts with the minute order. So I'll usually refer to the minute order, which is where I get my instructions. And then I'm making certain primarily that that information is contained in the report that's being presented to me.
What unit do you work with? You're not an ER
I'm
supervisor,
not.
right?
No, I'm not.
What do you guys call your unit?
Continuing services.
What does continuing services do?
I am responsible for overseeing cases where primarily where family unification and family maintenance services are in effect, but on occasion I also help facilitate PP services, permanency planning services. So I'm typically what they refer to the back end.
Okay. So when I see something in the policies or in the training that refers to back-end cases, that would be the work that you do.
That's correct.
Okay. In your 24 years with the agency, have you received training regarding the compilation of court reports?
Yes.
That would include detention reports,
Yes.
also interim review reports,
That would be correct.
last minute informations,
Yes.
status review reports.
Yes.
Do you recall receiving any training regarding your affirmative duty to disclose exculpatory information to the court in your court reports?
Yes, that's part of the court report training.
Okay. And you've taken that training.
Yes.
What is exculpatory information, as far as you understand it, based on your training?
It's information that we gather to support an argument and or any findings, factual findings in a case.
That's exculpatory information?
That's my understanding.
What do you call information that would be favorable to the other side, like a parent in this case? What would you call that sort of information? If your agency is making allegations against a particular parent and there's some information that would undercut your allegations, that would be favorable to the parent, what do you call that?
I call that information, investigative information that needs to be reported.
Okay. Let's see if we can't clarify things a little bit. We'll mark as exhibit number 1 a document containing 6 PowerPoint slides, one of which in the upper left-hand corner is titled Exculpatory Evidence. Hey, ma'am, if you can take a look at the slide in the upper left-hand corner there. I only have one, so we all sort of have to share.
Yeah, I have.
Yeah, you know what I'll do is I'll just sort of read it aloud to all of us. That way we can, all share. It's titled Exculpatory Evidence, evidence that may be helpful to the other side. The second bullet point is you have an affirmative duty to disclose. The third bullet point states failure to disclose means you can be sued as well as lose your job or your case. First of all, I'll ask you, did I read all that correctly?
Yes.
Okay. Does that refresh your recollection as to what is meant by the term exculpatory evidence within the context of the work that you do as a social worker?
Yes.
Okay. Am I correct that you have an affirmative obligation to disclose exculpatory evidence to the court in your court reports?
Yes.
Okay. And if you fail to do that, you could be sued and could lose your job, right?
According to that information, yes.
Do you recall receiving similar training at some point during your career with the County of Los Angeles Department of Children and Family Services?
Yes.
Okay.
I do.
Do you recall at what point in time it was that you were trained on exculpatory evidence?
It was during the time that we had a warrant training some years ago.
The warrant training, was that detention warrant training or search warrant training?
Detention.
Detention. And that would have been, do you recall when you took that? It was sometime in 2010, right?
You know, I don't recall specifically. I wish I did.
Do you recall it generally being in 2010?
I don't want to give you incorrect information.
Okay. Do you recall that the first ever warrant policy with regard to obtaining a detention warrant was promulgated in or around December of 2009?
That could be correct. Are you asking me, or are you just providing me
I'm
information?
asking you.
That could be correct. As indicated, it's difficult for me to give you specifics as to the year. I wish that I could.
Okay, and then am I also correct that shortly after that warrant policy was released, the County of Los Angeles Department of Children and Family Services undertook a regimen of training in relation to that policy?
That would be correct.
And that training consisted of training to emergency response supervisors and continuing services supervisors also at some point, right?
That would be correct.
Do you remember whether that was in 2011 or 2012?
I don't know the dates, and I don't want to give you incorrect information.
When is the last time that you had this warrant training?
It would have been that time that I don't recall specifically.
When was the first time that you recall having the training relative to Government Code Section 820.21?
If you could clarify that for me, I'd appreciate it.
That's the one that prohibits you and your workers from committing perjury, fabricating evidence, suppressing exculpatory evidence, or obtaining evidence by use of undue influence. It's that training. When do you recall first having that training?
I don't recall the exact time that I had that training.
Was it within the last 2 years?
I don't recall.
Okay. Did you bring any training materials here with you today?
I did not.
Okay. Is there a reason you did not?
I wasn't aware that I needed to.
Did you review any documents in preparation for your deposition here today?
I did.
What documents did you review?
The documents that I signed, which would include an interim report and I believe a jurisdictional report.
I'm sorry, you said detention report?
No, I said an interim
report.
as well as a jurisdictional report.
What about last minute informations? Did you sign any of those?
Not to my knowledge.
Okay. And then you said you also signed the jurisdictional report?
I believe that's the case, yes.
Have you ever heard of the 5 commandments of court report writing?
Sounds familiar. It would have been some time ago during my CSW training, I believe.
Okay, so you don't specifically recall today what those 5 commandments are?
No, not in this moment, but if you refresh my memory, perhaps I can expound.
Okay, I'll try and do that.
Okay.
We'll mark as exhibit number 3 to your deposition a page containing 6 PowerPoint slides. The one in the upper right-hand corner is titled 5 Commandments of Court Report Writing.
I'm sorry. Okay.
Okay, I'll just read it right along here with you. It says 5 Commandments of Court Report Writing. Number 1, include everything, everything, everything in the report, with 2 exceptions. The first being nothing you discuss with county counsel, attorney-client privilege, and the second one being other confidential information. Commandment number 2, nothing is too trivial or unimportant or inconsequential that it can be left out of the report. And it says this is a corollary to commandment number 1. Commandment number 3, if it's not in the report, it never happened. And there's an exclamation point behind that one. Commandment number 4, spend time addressing every child and every parent. Leave no one out of the report. And number 5, write honestly, objectively, and professionally. Having reviewed that, does that refresh your recollection as to the 5 commandments of court report writing?
Yes, thank you.
Okay. What are some of the common problems that you see in your social workers reporting?
common problems?
Lex Foundation.
It's difficult for me to answer that because we try to avoid the problems because there's, in my opinion, little room for that when you're dealing with people's lives. So I'm not quite sure exactly what you mean. If you could clarify, I'll do my best to better answer the question.
And that's because these families that you and your subordinate workers interact with, they're directly impacted by the decisions that you and your staff make.
Yes.
Right? And it could be that they're directly impacted in a positive way, right?
It could be, yes, sure.
Or it could be that they're directly impacted by the family perhaps being torn apart. I'm right about that, aren't I?
When you say they, meaning the staff or the family?
The families that you're so concerned about because there's little room for error. That's what you told me, right?
I'm confused. I'm very sorry.
Okay,
I really want to answer your question.
That's okay. Just a moment ago, you told me that in the work you do,
Yes.
there's little room for error because of the impact it has on families.
Yes.
Right?
I did say that, yes.
And the first choice was it can have impact for the better, right? Can help
What can have
families.
impact?
The work you do. I mean, that's what we're
Yeah,
talking
sure.
about here
Okay,
today, right?
yes.
We're talking about the work you do.
Okay.
So you're with me?
I am.
Okay. Did you not tell me that the work you do can have a positive impact on families?
Yes.
And the work you do can also have a negative impact on families.
The work that social workers do if they're not careful, yes.
Right, if they're not careful. Okay. So for example, we wouldn't want a social worker to choose sides in a custody dispute, would we?
I'm not sure what you mean by that because very oftentimes our job requires us to make decisions that may be viewed as choosing sides. So it's a little, I'm a little confused by what you're asking.
So are you telling me that part of your job as a social worker is to choose sides?
I'm
in a
absolutely not
custody
saying
dispute?
that. No,
Sorry,
I'm,
sorry.
oh, I'm sorry.
We got to slow this down.
Okay.
and- I'm sorry. Start your question.
That's all right. What you're telling me is that in certain circumstances, it is your job to choose sides in a custody dispute.
I don't like the phrase choose sides because I don't think that's what we do. I think that we make decisions based upon what's in the best interest of the child. Some may view that as choosing sides, but I don't see it as choosing sides.
Well, what do you view it as, ma'am, when a social worker fails to put exculpatory information in their court report so that the court report makes one parent appear a better caretaker than the other?
How do I feel about that?
Can I have my question reread?
Question, well, what do you view it as, ma'am, when a social worker fails to put exculpatory information in their court report so that the court report makes one parent appear a better caretaker than the other?
If that is purposeful, then that's not okay. If the information is unknown, then a social worker is bound to report what they are aware of.
I understand how you may feel, but let's just go through that. As a supervisor, you are sort of like the captain of your unit, right?
I don't see it that way, but okay, yes. I am the leader of the unit.
You are
yes.
the leader of the
Yeah.
unit. You have 5 or 6 people under you.
Yes, that's correct.
They look to you for instruction,
They
for
do.
counseling, and for guidance.
They do.
And in order to give you some method of enforcing your authority as their supervisor, you can discipline your social workers in some way if they don't follow your instructions, can't you?
I don't discipline, no.
Let's back up and
Okay,
lay a little
I'm sorry.
foundation. That's okay. You've been a supervisor for 17 years. Yes?
That's correct.
And when you first became a supervisor, you got some training regarding how to be a supervisor, right?
That's correct.
And then over the course of the last 17 years, you've had recurrent training about how to be a supervisor,
That's
right?
correct.
How to command your unit, right?
Yes.
Okay. And part of that training, you learned that as a supervisor, you have the ability to met out some form of discipline to your social workers, whether that be counseling, a letter,
Yes.
recommendation for terminations, that sort of thing, right?
Meet out. Yes.
Okay. So I'll go back to my original question. If you found a social worker that purposefully suppressed exculpatory information, would you mete out discipline of any kind?
Yes.
Okay. Have you ever done that before in the last 17 years that you've been a supervisor?
In terms of information that was purposefully detrimental to the client that was in a court report, is that what you're specifically asking about?
I'm asking you if you've ever had a social worker who purposefully did not disclose exculpatory information in a court report. Have you ever had that happen that you know of?
You know what? I can truly say not to my knowledge.
Not to your knowledge. And if it did, would you discipline that person?
I would certainly conference with that person, and I would certainly conference with my superior in terms of the best strategy to handle that. Yes.
Which superior?
Would be my direct superior, which would be my ARA.
Okay. Interim review reports, though, you've reviewed hundreds of those, right?
I don't want to get caught up in numbers, but yes, I have reviewed extensive interim reports.
Well, let's figure it out. You've been a SCSW in continuing services for 17 years, right?
That's correct, or so, yes.
And part of your job duties in that 17-year period has been to review reports filed by your subordinate social workers, and in some instances sign them as well, right?
That's correct.
Okay. On average, over the course of the last 17 years, would it be fair to say you had somewhere between 5 and 7 subordinate social workers?
I would say that would be fair to
Okay.
assume.
And for those 5 to 7 subordinate social workers that you've had on average over the course of the last 17 years, your job duties were pretty much the same, and that is, at least with regard to court reporting, reviewing last-minute information, status review reports, and interim review reports. You'd review them, and in some instances sign them, right?
That's correct.
Okay. We know in this case there were about 10 in just one case. Is that about average?
I don't want to get caught up in numbers because I don't want to give you wrong information.
Okay, let's try this. I don't know if your attorney has admonished you yet or not, so I'll go ahead and do it. During the course of this deposition, I will ask you questions. Some may relate to numbers. If you don't know the specific number, you can tell me I don't know the specific
Okay.
number. That's perfectly fine. But I'm entitled to your best estimate. So the fact that you may not want to give me a number or a range of numbers, that does not prevent you from giving me your best estimate. Do you understand that?
I do.
Okay.
And I would love to give you the range that you like. I just don't know the number.
Okay, well, we know, for example, right now, what do you have? You said, I think, 7 workers under you?
I think she said 5.
Is it 5 right now?
That's correct.
Okay, 5 workers under you. How many, on average, how many cases does each worker carry in their caseload? Just right now.
Right now, I would say it's about 30.
Do you have 10 court cases right now that you supervise?
Yes.
Okay, do you have 20 total right now?
There very well may be 20.
Okay, and in each of those 20 court cases that you have right now, there's going to be at least one status report, right?
At least, yes.
Okay, so we have 20 status reports we're talking about.
Okay.
Just right now. This isn't even over the course of the last 17 years. This is just right now.
Okay.
And then you also do jurisdictional reports, I think you said, right?
On occasion, yes.
Okay. And then you also do last-minute informations.
On occasion, yes.
Okay, how many last-minute informations did you review in the last 2 weeks?
I don't recall the number.
More than 10?
In the last 2 weeks?
Yeah, the last 2 weeks.
I don't recall any, actually, in the last 2 weeks.
So with the 150 cases that your subordinates are handling right now, you don't recall reviewing a single last-minute information within the last 2 weeks?
I don't.
Okay. So can you give me a rough estimate as to how many court reports of any kind, whether it's a status review, an interim review, a jurisdictional report, a last-minute information, how many you have reviewed over the course of the last 17 years? More than 500?
I don't know. A lot. I don't know if it's more than 500, but hundreds, I would say.
Hundreds, okay. That's better than your previous
Okay.
answer.
I'm trying to work with you.
Okay. So hundreds. And in your review, of those hundreds of reports over the last 17 years, have you developed an understanding as to what some of the common problems are in court reporting?
Common problems in court reporting. We try to avoid the common problems.
What are the common problems that you try to avoid?
But I will say this. On occasion, I serve as a duty worker. And while I'm pleased to say that I don't experience a lot of those problems that I see with other workers in my unit, I do encounter certain situations as a duty worker in that regard.
Okay, we'll get to that in a second. I actually want an answer to this question, though. My question is, what are the common problems that you try to avoid?
Okay. Grammar is an issue. Clarification is a big issue. For example, I like to make certain that the workers put the title and the telephone number, be as specific as possible. That's a common scenario for me in working with my workers, making certain that the reports are thorough.
What do you mean by thorough?
For example, if they're going to speak to an agency, the full name of the agency, the telephone number, the title of the individual, the date in question, those kinds of specifics.
Okay. So I've got three here: grammar, clarification, and thorough in the specifics when they're referencing an agency or a witness or something.
And facts, of course, too.
Okay. So thorough in their facts?
That's correct.
What do you mean by that?
The gathering of the information.
What else?
Primarily the gathering of the information in terms of the facts that are found.
Is that all you recall in terms of the common problems you try to avoid?
At this time.
Okay. I'm going to mark what we will identify as exhibit number 4 to your deposition. It's another page containing 6 PowerPoint training slides. The bottom right-hand corner, there's a training slide titled Common Problems. And I'll get that marked. Here, I'll just read it. We're going to read anyway. So, okay, it's titled, first of all, it's in the bottom right-hand corner of exhibit 4. It's titled Common Problems. Number 1, not including information that negates, undermines, or refutes a recommendation, position, clinical decision, or allegation in a report, i.e., exculpatory evidence. Number 2, not summarizing or restating information in documents you're attaching to a report. Number 3, not identifying all witnesses mentioned in the report. Number 4, not informing the court how you came to hold or receive such information. And number 5, not including all the information you have regarding the paternity of a child's possible American Indian heritage, or an incarcerated parent's plan for their child. First of all, I'll ask you to take a look at that and tell me if I read it correctly.
And this is the common problems box only,
Yes.
correct?
Yes.
Yes, it would appear as you read it correctly. to me.
Okay. Having now read this training slide, does that refresh your recollection as to what you have been trained some of the common problems in court reporting are?
In general or with my workers?
In general.
Yes, I've been trained in that regard, yes.
Okay, and you've been trained that one of the common problems that we see in court reporting is the social worker not including information that negates, undermines, or refutes a recommendation, position, clinical decision, or allegation in a report, i.e. exculpatory evidence, correct? You've been
Correct.
trained that. Yes.
Correct, I'm sorry.
Okay. And you've also been trained that another one of the common problems that we see in court reports is the social worker not summarizing or restating information in documents that are attached to a report.
That's correct.
Looking at the bottom of the page, there's 2 signatures there, right?
Yes.
Do you know the signature on the left-hand side, whose signature that is?
I do.
You recognize it?
I do.
Okay, and who is that?
Carla Hosh, that would be one of the social workers I supervise.
Okay, and you currently supervise her, correct?
I do, yes.
Okay. I'm going to show you what we'll mark as exhibit number 6 to your deposition. It's another last information for the court dated August 10th, 2011. Do you recognize any of the signatures on that?
I do.
You recognize Ms. Hodge's signature down on the left-hand corner, right?
That's correct.
Is that your signature down in the right-hand corner?
Yes, it is.
Okay. Did you review this document at all in preparation for your testimony here today?
No, I did not.
Okay, as a judge sitting here reading this, what is it, and you signed it, right?
I did, yes.
And you reviewed it before you signed it?
That's correct.
And when you signed it and reviewed it, you knew it was going to be filed with the court, right?
That's correct.
It's an official document, right?
Yes. Mhm.
And you anticipated that the court would accept it into evidence, right?
Yes.
And that the court would consider it to be true, right?
Yes.
Okay. Well, you didn't think that the court would look at it and say, oh my gosh, this is all lies, right?
Did I think that the judge would look at it and say it's all lies?
Yeah.
No, I didn't think that.
No, of course you didn't.
No.
You thought that the judge would accept it into evidence and rely on it, right?
Yes, sir.
So as a judge sitting here looking at this, where you, what is it that you wanted to convey to me as the judge? What did you want me to
Well,
take
this
away
was-
from that?
Oh, I'm sorry.
Lacks foundation.
Information as provided by the author pursuant to information obtained by the therapist.
If we look back at exhibit number 4, the second common problem in court reporting, not summarizing or restating information in documents you're attaching to a report. Why is it that you need to summarize or restate the information in the documents that you attach to a court report?
For point of clarity for the courts.
Point of clarity for the courts. We don't want the court to be misled
That's correct.
by a short statement, right?
Sorry to interrupt you.
Right? We don't want the court to be misled, right? Yes?
We do not want the court to be misled, no.
Okay. And that's the reason that you and your social workers are trained to summarize and restate information in documents that you're attaching to the report, right?
That's correct.
So again, I'll ask you, as the judge reading this, are you telling me the father, and you're leaving it to me to go look at the letter from the therapist? Is that it?
My guess would be that my worker had a conversation with the therapist and indicated what was said by the therapist, in addition to attaching that information from the therapist.
And you didn't participate in any such conversation, right?
What conversation are you referring to?
The one you just told me about, that you assume your worker had a conversation with the therapist. You weren't there, were you?
No, I was not there, sir.
And you didn't call up the therapist to verify that, yes, in fact, okay. And yet you signed the bottom of this.
That's correct.
Official document that the court is going to accept into evidence and rely upon.
That's correct.
Okay. What is the purpose? What's the point of you signing this?
I trust the integrity, professional integrity of my workers.
I understand that you may blindly trust the professional integrity of your workers. My real question is, though, what is the purpose in placing your signature on this official document?
Okay, I'm sorry. What is the purpose of me signing the report?
This
Is that what the last minute?
This last minute information that we're looking at
Because
right now.
that is my duty as, oh, I'm
Hold
sorry.
on.
Okay,
This last minute information that we're looking at right now, exhibit number 6.
yes.
What is the purpose in you signing this report?
Because that suggests that I have reviewed the report and I'm signing off on it pursuant to our policy.
So you're not signing it to say everything in here is true. You're just signing it because that's the policy?
I'm signing it because I trust that everything is true, because I trust the professional integrity of my worker.
Okay. What did you do, if anything at all, to verify your trust in this particular worker as to this particular report?
Well, I don't feel the need to verify my trust, because part of the reason that they were designated to have that job is because the expectation is that there's a certain amount of professional integrity, which I
Okay.
respect.
Okay, so let me make sure I'm getting this right. You sign these documents, these official documents that you're going to give to the court. You know the court is going to rely on these documents, the information contained in them, in making its decisions, right?
Yes.
And you sign these documents because you have an expectation that your social workers have been truthful and honest, accurate and complete and professional.
Yes.
Did you do anything at all to verify on August 8th, 2011, whether or not
I did not do anything to verify, no,
you trusted your worker?
absolutely.
Ma'am, before we took a break, I had asked you what you did, if anything, to verify that the information contained in Exhibit 6 was true before you signed it. And that's sort of what I'm actually asking you now, because your answer was essentially that you didn't need to because you trusted your worker. Am I correct that you did nothing? Scratch that, let me start over. Am I correct that you did nothing to verify the accuracy of the information contained in Exhibit number 6?
I had a conversation with my worker, and I believe the information that she was providing me. So I don't know if that constitutes doing nothing. I'm really...
Okay, let's listen very, very carefully
Okay.
to my question. Other than, I understand you talked with your
Okay.
social worker and you believe her wholeheartedly.
Right.
Okay.
Okay.
Other than speaking with your social worker, who you believe without question,
Yes.
did you do anything else
No.
to verify? Hold on.
Oh, I'm sorry.
Did you do anything else to verify the accuracy of the information that you guys were reporting to the court in Exhibit 6?
No.
Okay. I'll show you what we'll mark as Exhibit number 7 to your deposition. This is a letter from Ms. Cohen to you and Carla Hosch, dated November 15th, 2011. In reviewing this letter, does that refresh your recollection as to who Natalie Cohen is?
If I could take a minute to review it, I'd appreciate it.
Sure.
Okay, I've read the document.
You should understand that the oath you took here today carries the same weight and solemnity as the oath that you will take should this case go to trial. You understand that, right? Yes? Okay. And you should also understand that although the setting here is less formal than it will be at trial, it deserves the same dignity and respect as you would give a court of law while you're testifying, right?
Yes.
Okay. Do you have any understanding as to why it was Ms. Cohen felt compelled to send this letter on November 15th, 2011?
I do not.
Do you deny having received this letter?
I do not.
Turning next to what we'll mark as Exhibit number 8. Let me just say what it is. Exhibit number 8 is a last-minute information for the court dated November 16th, 2011. First, let me ask you, at the bottom of Exhibit number 8, we see 2 signatures. Do you recognize one of them being that of Ms. Hosch?
I do.
And the other is yours, correct?
Correct.
Did you do anything other than speak to Ms. Hosch in order to verify the accuracy of the statements that are set out in this Exhibit number 8?
May I take a moment to review the document?
Sure.
No.
Okay. First, did I read that correctly?
Yes, sir.
What did you do, if anything, to verify that that statement there in that sentence was in fact true?
Other than consult with my worker, I did not contact the source, for example, to confirm it.
You didn't talk to Mr. Weisman
About,
this statement that
I don't recall having a conversation with Mr. Weisman in this regard.
Looking here at the second paragraph of Exhibit 8, if you go down 4 lines from the top of the beginning of the second paragraph, it says, first, did I read that correctly?
Yes, sir.
What's the purpose of the quotation marks there?
To quote the therapist.
You're trying to let the court know that these are the exact words the therapist spoke.
That's what that would indicate, yes.
Okay. And again, this is like Exhibit 7. This is an official court document, right? This Exhibit number 8?
Yes, sir.
Okay. It's one that by statute you're entitled to file with the court.
Yes, sir.
It's one that the court will typically accept into evidence and rely upon in making its decisions?
Yes,
Okay. And here in the quotes, you're telling the court that these are the exact words spoken by the therapist, right?
as authored by my worker, yes.
Well, you signed it, right?
That's correct.
Okay. Aren't you also telling the court that you believe this information to be true?
Yes, I am.
That's why you put your signature on it.
That's correct.
To let the court know that a second set of eyes looked over this. It wasn't just the social worker.
That's correct.
Okay. Is that one of the safeguards that your agency has put in place to protect the rights of parents and children?
Yes.
And so we have a second set of eyes looking over what the social workers do to make sure that the social workers not only are meeting the statutory requirements in the forms, but also to ensure that they're being truthful, honest, accurate, and complete, right?
That would be correct.
Okay. And in order to ensure that this particular worker on this particular report was truthful, honest, accurate, and complete, all you did was speak to her about the report, right?
That's correct.
You didn't call anybody or verify anything with either Ms. Cohen or Mr. Weisman?
No, sir.
Okay. Was it your intent in filing this with the court that the court believe that the father was?
I'm sorry, I was looking at the document. Please repeat what you just said.
Can I have it reread, please? Okay, and if we go back to exhibit number, I think it's 7. That's the Natalie Cohen letter. Coincidentally, the letter's dated November 15th, 2011. Do you see that?
Yes, I do.
That's the day before this hearing for which you filed this last-minute information, right?
The letter is dated November 15th. I can't confirm when it was received or forwarded.
Okay, do you see those email addresses under your and Ms. Hosh's names in the upper left-hand corner? I know you can't read them.
I do not, yeah.
I know you can't read them, but there clearly are email addresses. I see the @ DCFS something. You see what I'm talking about?
I see something there, sir.
Okay, you have an email address at DCFS, right?
I can't see it, sir, if you could see my copy.
Ma'am,
Oh, do I? Yes,
my
I do.
question is,
Yes, I do.
Yes, you do. And
Yes,
so
I
does
do.
Ms. Hosh.
Yes.
Do you deny that this particular letter was emailed to you on November 15th?
I do not deny that, sir.
Okay. And here in this letter that coincidentally is dated November 15th, 2011, Ms. Cohen talks about a telephone conversation with you, right?
Yes, she does.
And you signed this thing and submitted this exhibit number 8, last minute information for the court. You signed it and you submitted it to the court knowing it would be accepted into the record as evidence, right?
Yes.
And you intended that the court rely on exhibit number 8 in making its decisions, right?
Yes.
Okay. And you do not deny that you had this email as of November 15th, 2011? Go ahead.
I cannot confirm when this email was received, sir.
That's okay. Ms. Cohen will do that for us.